Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I am a partner at the firm of Samfiru Tumarkin, LLP, and a Western Canada disability practice leader on all things disability, critical illness, and life insurance claims. So I welcome questions through all forms of social media. As they come through, I'll review them, and hopefully we'll get through all of them in the 30 minutes that we've got. So as you can see on the screen, you can send your disability questions to us right now. So we'll start with what to do when you have a potential claim, how to prepare for it. Now, if you've seen this before, seen any of these shows before, at the risk of sounding like a broken record, which I will, see your doctor regularly. It is extremely crucial that when you have a disability claim or you're planning on ceasing work because of a disability, that you see your doctor on a regular basis. I cannot emphasize that enough. If you do not have a doctor, try and find someone, try and go to a walk-in clinic, try and see the same doctor at a walk-in clinic. But it is imperative that you see the doctor on a regular basis. There are a few reasons for that. The first one is that when you submit a claim, you need to provide medical evidence that you cannot work. And the way to do that is by having the doctor on board, having the doctor confirm that you cannot work, having the doctor complete medical records, and during the lifetime of the claim, while it is being adjudicated by the insurance company, at times they will reach out to your doctor to request information, maybe to complete forms, and often to request copies of the clinical records, in other words, your clinical chart. If you are not seeing your doctor regularly, they will see that. If you are not seeing your doctor regularly, your doctor may not feel empowered or informed to provide a supportive opinion. So going back to what it is that you do when you submit a claim, if you find that you have restrictions and limitations that impact your ability to perform the regular duties of your occupation, see your doctor, have a discussion with your doctor, and through that discussion, make a decision as to whether it makes sense to submit a disability claim. Total disability under the terms of a policy doesn't mean that you have to be bedridden or comatose. It sounds very serious, total disability, but what it means in a contractual sense, in other words, in terms of the language of your policy, is that you must have, due to an illness or an injury or a condition, certain restrictions and limitations that will impact your ability to perform the essential duties of your occupation. Doctors don't always understand that either, because the phrase total disability can be confusing. So when there is a claim that is to be submitted, have the discussion with the doctor, and hopefully the doctor will agree, will complete the medical report outlining what the restrictions and limitations are. So when you do have that discussion with the doctor, you may want to take with the forms to complete. When the doctor completes the forms, do not have the doctor simply identify what the diagnosis or diagnoses are. The doctor has to outline what the functional impairment is. What are your restrictions? What are your limitations? I have said this many times. If you have a mental health illness like depression, simply saying my patient cannot work because they have depression will lead to a denial. 100% that claim will be denied. It has to be outlined why it is that because of the depression diagnosis, you are functionally impaired from performing your duties. Many people with depression are able to work. They are being managed on medications. Their job duties may have been modified. So in a case where you submit a claim to a disability insurer, it's not the same as when you submit a sick note to an employer, simply saying that my patient cannot work, these are the restrictions and limitations. With an insurance company, because it is based on a policy, you have the duty to explain and to prove why it is that because of this illness, you are unable to perform the duties of your occupation. Therefore, outlining what the restrictions and limitations are is absolutely crucial. If you did all of that and your claim is denied, then you have options, and you want to know what those options are, and you want to know what those options entail. So if your claim is denied, please reach out to a disability lawyer. We have offices in Alberta, Ontario, and BC, and we can discuss with you what your options are, review the denial letter with you, hopefully being able to review the policy with you, discuss your circumstances, so you can then make an informed decision as to how to proceed. As you can see on the screen, you can go to disabilityrights.ca. Also, it's important to understand that we do offer free consultations. So when you contact us, we will review all the documentation, discuss your options with you, and then you make a decision as to how you want to proceed. So I'm going to go to some questions. The first one is from Yusuf on YouTube. And Yusuf says, I have two insurers and I did apply for CPPD. How would that work with the offset? This is an interesting question and it's a complicated one. It all depends on the language of the policy. Each insurance company will want to deduct the CPP disability offset. It depends, of course, on the language, but there's also, of each policy, there's also something called reintegration of benefits. So it's not something that I can give you an answer as to which insurer will be able to deduct what. We will have to review the policies. So if this does happen, if your CPP disability is approved and, excuse me, both insurers will want to deduct it, it will depend on what the language in each policy says. So when that happens, you're welcome to reach out to us, when you have a decision at least. Linda Bell says, what do you do if your insurer is claiming your condition was pre-existing? Linda, I'm sorry, this is a very difficult situation to navigate at your end. I can speak about pre-existing conditions for hours because every week we get contacted by someone whose claim has been denied because the insurance company said your disability is related to a pre-existing condition and is therefore not payable because it is excluded under the language of the policy. First things first, basics. The policy is a contract. The contract has rights and obligations and provisions. Speaking generally, the vast majority of policies, long-term disability, not short-term, long-term disability policies with group insurers will have a provision that if you go off work within the first year of having long-term disability coverage, then the insurance company is going to investigate whether your disability is directly or indirectly related to a pre-existing condition. If it is, your claim will be excluded. Therefore, when you go off work within the first year, the insurance companies are motivated to investigate whether your claim may be excluded based on the pre-existing condition exclusion language. Every policy, in my experience, when it is a group insurer, has language related to pre-existing conditions, but they do not all read the same. And this is where the difficulty comes in. Linda, for you, we would want to review what the policy says because your pre-existing condition definition may not be the same as someone else's. In general, what does it mean? When you hear the phrase pre-existing condition, you simply think it is something that existed before. If it existed before, my claim must be excluded. That is not correct. Many policies have specific definitions for the pre-existing condition. Let's assume that the person goes off work within the first year of having coverage. That triggers the pre-existing condition investigation. The language may be as follows. If your disability is directly or indirectly related to a pre-existing condition for which you received medical care during a defined period of time, your claim will be excluded. Some policies may provide that if you received medical care during the 90 days prior to your coverage becoming affected for that condition, which is directly or indirectly related to your disability, then the claim is excluded. The phrase medical care may also be a defined term, which may mean that medical care could include if you consulted a doctor, if you were referred to a specialist, and if you were taking or prescribed prescription medication. Because it is language in a contract, it has to fit within that language. So when we deal with pre-existing conditions, we look at, does the language in the policy capture the facts? If there is ambiguity, for example, you may have been seen for an anxiety condition, but your disabling condition is depression, there is an argument to be made that it is not a pre-existing condition. If you had had depression your whole life, and for the 3 months, which is the timeline during which the insurer is investigating whether you received medical care, if you did not receive medical care for that, the depression condition, and depression ultimately is the disability or the cause of this disability, even though it may be a pre-existing condition in the general sense, in the everyday meaning of that phrase. When we look at the policy, if you did not receive treatment for those 90 days, It is not a pre-existing condition. As much as the insurer may want it to be, it is not. So it is crucial that when you have a denial based on a pre-existing condition, that you contact a disability lawyer so that the lawyer can review the policy wording. What does pre-existing condition mean in your context? What are the actual disabilities? Are they related? And what does the medical chart show? Did you actually receive medical care? Did you receive care for that condition? Is that condition directly or indirectly related to your disability? So it is a very, very fact-specific individual analysis of your particular claim. I cannot emphasize that enough as well. Sometimes there is nothing to be done because it simply is a pre-existing condition. But often there is an argument to be made as to why it is not a pre-existing condition. So do contact us, Linda, so we can review your circumstances and the policy with you. Then there's a question from Last Dropper 33. I suffered a serious injury in a car accident. I have to take a lot of pain medication and it causes impairment. My insurer is claiming that I can work while medicated, but this isn't true. What should I do to prove that the medication makes me unable to work? I'm going to go back to my opening statement today, where I said I'm sounding like a broken record. It is crucial that your doctor weighs in on this. You say that you've suffered a serious injury, you're taking pain medications which cause impairment, and I understand why. It may make you confused, it may make you feel groggy. Quite often when you have medications like that, it may say that you're not even supposed to be driving because it impacts your ability to focus and concentrate. In a situation like this, I would strongly suggest that you reach out to your doctor and have your doctor write a letter identifying, number one, what your disability is, number two, what your duties are, number three, what your restrictions and limitations are, and number four, what medications you are taking and how those medications impact your ability. Like you say, you are impaired, obviously from a cognitive perspective, I would think. So if that is the case, have the doctor outline globally what your restrictions and limitations are. So you suffered an injury, so what are the physical restrictions and limitations? And because of the medications, what are the cognitive restrictions and limitations? If the insurer still denies your claim, or if you want to have further discussions, again, you're welcome to reach out to us. I have seen situations like this, and I often speak about this in the context of do not simply speak about the physical restrictions and limitations, as you can see on the screen, again, go to disabilityrights.ca, but also speak about the cognitive, the emotional, and the psychological restrictions and limitations. What that means is often when we speak about mental health cases, or if you take medications for some other condition, the medications and the effect that they have on a person, like with strong antidepressants, quite often the person may not have any motivation, they may have low energy, they may have confusion, they may feel groggy. All of that also has to be taken into consideration to consider whether the person is functionally impaired from performing their duties. So last dropper 33, I hope that was helpful. If not, contact us and we can discuss it with you in further detail. Okay, a question on Reddit from Cameron Pham. I suffered a TBI a few months ago, so that is a traumatic brain injury. I have been dealing with a number of problems as a result: vision loss, anxiety, brain fog, headaches. I've just started some treatment for this and my insurer has already requested a return to work plan. Can they push me into this before I am ready? I need enough time for the treatments to help me improve first. Do you know what insurers often do? They look at what is the condition. For example, in this case, it would be a traumatic brain injury. Then they go to get an opinion in-house from one of their doctors, or they may actually look online. What is the expected general recovery timeline for a traumatic brain injury? Now, often it would say it could be 6 to 8 weeks or 3 to 4 months, whatever the timeline may be. But it's a general sense. And then they rely on that to say that we believe that you have now reached the timeline where you should have recovered. Therefore, we expect that you will have recovered. Obviously, applying a general consensus to an individual situation is not ideal. So again, in a situation like this, like with every time I have this discussion, you want to get your doctor to be on board. This is why it is crucial that you see your doctor on a very regular basis, especially in this case, because there's a traumatic brain injury which is expected to recover. There's a small percentage of people who do not recover and who do continue to have ongoing restrictions and limitations. It's also referred to as a post-concussion syndrome, which quite often, if you did an MRI or a CT scan, you may not see that there is any abnormality. Yet the person continues to struggle with issues with vision, anxiety, brain fog, headaches, difficulty to concentrate, other cognitive impairment. In the face of imaging that shows that there are no abnormalities, these cases are often denied. So you want to be sure that your doctor is proactive, that you are referred to a neurologist if it is necessary, that you're taking the appropriate medications. And in a situation where the insurer is pushing you to return to work, if your doctor disagrees, follow your doctor's advice. Have your doctor put in writing again, outlining why it is that you're unable to work, why a return to work may be completely detrimental and may be counterproductive. Sometimes we do find that people return to work early, and because they do, they may suffer a setback, and any gains that they may have had may now have been eroded, so that the disability itself is now prolonged to the point that that return to work actually was harmful. In your situation, obviously it is your health, so you want to be sure that you are able to return to work when you are ready. But if you're pushed to return to work too early, you may face a termination, or you may face that return is worsening your condition. So it's crucial that your doctor weighs in on this, writes a letter outlining why a return to work is premature, what the risks are, and that the doctor supports that you remain unable to work and that you should continue to receive benefits. If the insurer denies you, or if you want to discuss this further, again, as you will see shortly on the screen, go to disabilityrights.ca and contact one of our lawyers. We can simply review it with you and have a discussion with you as to how to proceed and what your options are. Lee says, if you are not taking meds prescribed by a psychiatrist, is that grounds for refusal? It's a good question because sometimes I discuss what are the grounds for denial, which we regularly see. Sometimes it may be that the person is not submitted objective medical evidence, or that they are not being under the regular care of a physician, or that they are not following through with recommended treatment advice, which in this case would be potentially applicable to your situation. So let's read that question again. If you are not taking medications prescribed by a psychiatrist, is that grounds for refusal? It depends on what the situation is. I have had clients and have represented clients who did not take medications because they may have had an adverse side effect from before. Some people are significantly, I don't want to say allergic, but I suppose that's one of the ways to describe it, but very sensitive to medications where they have suffered significant side effects. I've represented clients where they've tried various antidepressants, which created significant side effects. Some may have become suicidal, others may have become extremely aggressive, others may have found that there was just simply no benefit and they felt completely zombified, if you want to use that phrase. In those contexts, the doctor also was on board because the person did try, and the doctor said, well, I understand they've tried this, let's try something else. Let's try counseling. So if the doctor is on board, in other words, understands why it is that you're not able to take these medications, that should go a long way, and the insurance company should not deny your claim. If there are other reasons why you're not taking the medications, and I'm not sure what those are, then it may become more difficult to argue that position. If you're simply refusing to take medications, and there are reasons. I've had clients who have struggled because somebody in their family may have become addicted to certain medications. There may have been suicides. It's a very difficult discussion to have. And that they were petrified that they may go down the same road. They were petrified that may have a habit forming addiction to the medications. So there's a very, again, fact-specific assessment. And I would want to know more as to why it is that there is a refusal to take the medications. And maybe in the context of the discussion with the doctor, try some other treatment options, like counseling. I hope that was helpful, Lee, but again, you're welcome to contact us to have a consultation to discuss it further in detail. Crash into 2 says, is arthritis something that you can go on LTD for? I'm starting to lose mobility and my doctor has said it will worsen. I'm only 47 and won't likely make it to retirement before I cannot work. Okay, so there's a lot to be said about this. Is arthritis something that you could go on LTD for? Yes, it is. It depends on the functional impairment. Like I said before, if you have depression and the doctor says you cannot work, your claim is going to be denied. People with depression work, some cannot. So you have to explain why it is that you cannot work. With arthritis, if it's osteoarthritis or rheumatoid arthritis or a different type of arthritis, because we know some of these conditions, it depends on what type it is, may be more progressive, may be less amenable to treatment, may be more disabling. So it depends on what's happening. If you're 47 years of age and you're losing mobility and your doctor tells you that it will worsen, first thing that I will say, see your doctor regularly. Have discussions with your doctor as to whether you find it difficult to work. Does the arthritic condition, impact your ability to work? Does it impact you in the context that you have to now have modified duties, or you go home and work after work and you cannot do anything else? You're in pain, you're taking significant pain medications. All of those are things that should be considered. So you also do not want to be in a position, I've said this many times before as well, where you start to reduce your work hours because of your condition. You carry on working like that for 2 or 3 years, and then you find that when you do go off work, because you simply cannot do it anymore, that either you don't have enough hours now to make a claim because you need to work a minimum of hours to have coverage, that you literally may have worked yourself out of a claim, or that your LTD benefit is now much lower than it would have been because you continue to work lower hours. And the long-term disability benefit is calculated on your income at the time that you stop working. So I'm not saying that you should stop working now if you're able to work. But if you are struggling and your position or your duties are being modified and you're starting to work fewer hours, or you're taking extra sick leave, and your doctor is concerned that you cannot carry on like this, it is a very, very important discussion to have with the doctor as to whether you should consider taking time off work and applying for total disability, LTD benefits at least. But you do not want to carry on like this, work fewer hours, as I've said, and then later on find that you cannot apply anymore or that your benefit is low. But that, again, is the theme of the day. Have the discussion with the doctor and see whether the doctor agrees. Take your medications, but again, if the medications impact your ability to work as well, all of these things globally must be assessed as to whether it is time to apply for disability benefits. Graham Soth says, I just received a letter that after an investigation, my insurer believes I can return to work and not paying you off. What investigation? I'm very confused. There has been no changes on my end. Okay, so the word investigation is somewhat concerning. It may mean that the insurance company internally investigated or looked at the medical records by having one of their doctors assess it. Or it may be that the insurance company conducted an external investigation, which may be surveillance. It may be surveillance that they conducted through the help of a private investigator, where they actually followed you around and recorded you. Or it may be that they retained an investigator to conduct online surveillance. I say this often, social media is a gold mine for insurance companies, because often people would be posting pictures. Sometimes it may be pictures from 10 years ago, where the insurance company says, well, look what this person is doing, considering what they're reporting to us now as to what they cannot do, there is an inconsistency. So, Graham, if there is investigation that has been done and they are cutting you off, you really, in that context, should speak to us. Investigations or surveillance can be overwhelming. The thought of it can be overwhelming. It can be quite intimidating when an insurance company says, we've got you, we did surveillance, we believe that you're not disabled. And what they're really saying is, we've seen you do things that in our mind is not consistent with what you've been reporting to be your restrictions and limitations. Now, everything has to be seen in context. If you were active taking out the garbage bins one day, where you say you cannot push or lift heavy items, but then you struggle and do not leave the house for the next 2 days because you did that, things have to be seen in context. It has to be considered whether a person has a good day and then struggles after that. If surveillance is done and often say, well, let's say they did it for 5 days, they see the person being active 2 days. What happened to the other 3 days? It is consistent because somebody may be reporting that they can do certain things, but then they pay for it afterwards if they went beyond their limitations. So in your situation, if that is what happened here, that is something that should be discussed. So again, reach out to us and we can review it with you. Remember, we offer free consultations. You don't need to retain us. It's just we will discuss it with you and you can make a decision as to what makes sense. As you can see on the screen, go to disabilityrights.ca. I hope that was helpful, Graham. Do not be intimidated by the insurer, please. If you receive the letter, I know it is very upsetting, but have a discussion with somebody who deals with disability claims all the time. Okay, and there's another question. I just have to look at this. Do they not have to notify me of surveillance? I will give a call. Thank you. No, they don't. They don't tell you, and they are allowed to conduct surveillance. They're not allowed to bug your phone or enter your house or monitor your emails, things like that. But no, they're not going to tell you that they've conducted surveillance if that is what they do. So no, they don't have to tell you. Question on YouTube from Tumarkin36. I was in a car accident and suffered neck and spinal injuries. I'm on very heavy pain medication and have mobility issues. My insurer has been slow to respond to my requests. I've been trying to continue to work to make ends meet, but won't be able to do so for long. Sorry. The argument is that because I'm still working some, I must be able to return. What can I do? Tough situation. Again, do not work yourself out of a claim. If you've suffered injuries, you're having difficulty with mobility, you're taking strong medications, as we've said with the previous person who asked the question, it is impacting your ability to focus, to concentrate, to memorize, to multitask. It really depends on what your restrictions and limitations are. So if you've been trying to continue to work to make ends meet, you're damned if you do and you're damned if you don't in some instances. So if you do work, the insurer may look at that as increased capacity. If you do not work, they may say, well, we think you can work. So again, see your doctor extremely regularly. If the fact that you are working is also impacting your functionality, in other words, you work a few hours a day, but then after that, you have to take time off. You need to rest. You cannot do anything around the house because that's all that you're able to do. Your doctor needs to know this so that when the doctor does ultimately agree that you need to stop working, the doctor can do that based on an informed opinion, based on the fact that the doctor has observed you when you report to the doctor how the return to work or how the actual work itself is also impacting your disability. So see the doctor regularly, and if they are pushing you, reach out to us and we can discuss with you your options. So we've got a few minutes left. Lee says, the reason is psychiatrist said I have psychosis, but I want a second opinion from another psychiatrist. So I thought to delay medication. Is that a bad idea? I am on sick leave, paid, but not yet LTD. It's a very difficult question to respond to, because the insurance company, and yes, they're not there yet, but you also have to prove that you are disabled during the waiting period based on the language of the policy, and you are now in the waiting period, not yet on LTD. The LTD waiting period may be 4 months, it may be 6 months, sometimes it may be a year. So you have to prove, number one, that you're under regular care, but also that there is proper treatment in place. I think in a situation like this, it might make sense to have a discussion with your family doctor as well, hear what the family doctor has to say, whether the medication at this point should wait and whether you should receive a second opinion. From the insurance perspective, they may look at this and say, well, you have seen a specialist because the psychiatrist is a specialist and you should be following through with treatment. But I am very careful here to not say to you, you should be doing that. That is a discussion between you and your doctor. What the insurer will do with that, I'm not sure. If you do want a second opinion, I think that's something that you should be having a discussion with your doctor about, and probably sooner than later. If they ultimately do deny you, based on this, let's say you decide not to take the medications because you are concerned about the diagnosis and how these medications may impact you, and you've had a discussion with your doctor who may agree with you, reach out to us and we can see whether there is an option. There's always an option, but how to deal with it. And we can discuss this in further detail with you. Okay, finally, again, go to disabilityrights.ca for any more questions. Thank you so much for all the questions. It was I enjoy responding to these because they were very interesting questions. If you have any further questions, by all means, please reach out to us and we can have further discussions with you regarding your specific situations. Our next session is an employment law Q&A, and that is on Thursday, November the 7th at 1 p.m. Eastern Standard Time, so that would be 4 p.m. Pacific Standard Time, and that is with Travis Carpenter. So if you've got any questions regarding your employment situation, wrongful dismissal, or any issues with your employer, reach out to Travis on that day and respond to your questions. Thank you, everyone, and see you next time.